Good afternoon, ladies and gentlemen. I hope it has been a fruitful morning so far for everyone since our opening ceremony earlier this morning. To kick off our series of webinars, we are so excited to have Geraldine here with us today. A specialist in IP and IT law, Geraldine has extensive experience in advising and assisting clients in growing their business and brand presence through franchising, licensing, and distribution arrangements. She also represented clients of different profiles from diverse industries such as education, fashion, food and beverage, hair and beauty, hospitality, IT, and manufacturing. She also regularly advises on data protection regulatory and compliance concerns and general commercial transactions. Geraldine graduated from National University of Singapore with a Bachelor of Law degree with honours and was called to the bar in 2006. Please join me in welcoming Geraldine as she shares on the topic of pitfalls to avoid when signing a franchise contract. Geraldine, please.
Thank you, Maisie. Good afternoon, everyone. Welcome to today's webinar on pitfalls to avoid when signing a franchise agreement. Okay, let me just put up the slideshow. Okay, yes. So the focus of today's session will be on the legal aspects of a franchise relationship, and I'll be covering some of the common legal pitfalls to avoid when entering into a franchise agreement. Okay, so many of you here today are probably interested in buying or granting a franchise, and some of you may already have some experience in buying or granting a franchise and are keen to find out more. Whatever the case, there will be something for each of you today, whether you're a franchisee or a franchisor. So without further ado, I will dive straight into the first pitfall. Pitfall number 1, failing to secure your IP rights and protection. Okay. As you know, franchising involves the grant of a range of IP rights that are relevant to the operation of a franchise business. Okay. A strong franchise system will have a strong portfolio of IP rights, and this includes typically trademarks. This takes the form of the name or the logo of the business, copyright. In every franchise, there will be operation manuals, training manuals, marketing material, and software. And these documents are protected by copyright. And for some businesses, there may also be the licensing of patented processes, or your products might involve some patents, and you may need to license these to your franchisees. There's also trade secrets. For F&B sector, this could be recipes of your products. It could also be techniques or know-how or processes which you need to impart to your would-be franchisee. So I think it's quite clear to us that the value of the franchise system resides in its intellectual property. So seeing that this is the case, what does this mean for the franchisor? Okay, I think it means the franchisor has to ensure that this house is in order before it grants any franchise. What does this mean? Have you secured your IP rights? Are your IP rights well protected? A franchisor cannot grant a license for something it doesn't have, right? Otherwise, it will risk being in breach of the agreement or infringing the rights of third parties. This may also mean for the franchisor building up a portfolio of IP through the registration of trademarks and other relevant registrable IP. Franchisors should also give due consideration to how they can secure the IP that's licensed to franchisees to prevent any leaks or inadvertent disclosure or loss of its IP, whether this takes the form of trade secrets or copyrighted documents. So let's zoom in on trademarks, which is a key IP of a franchise system. For any franchisor, I think a key consideration would be, have you filed or registered your trademarks, the relevant trademarks to the franchise business? I think this, first of all, the first step you should be doing is to identify what are the key trademarks for the business. Have these been registered in the right territories? So you need to align your IP portfolio with your franchise strategy. So if you're thinking of expanding into certain countries, make sure that You would want to secure your rights in those countries as early as possible by filing your trademarks. You might want to also consider whether the trademarks have been filed in the right classes of goods and services. So trademarks those familiar with the registration of trademarks will know that when you register a trademark, you can only register it in respect of a specific class of goods or services which are relevant to your business. So it will be important with the counsel of your trademark lawyer to find out which are the relevant classes of goods and services you should be seeking protection of a trademark. Well, one of the things you should be looking out as well as you enter into new territory is perhaps conducting a trademark clearance search. You want to ensure that you have freedom to operate in the territory, that no other person has actually registered a similar or identical mark before you have entered the territory. Because if there's an earlier mark that's already registered on register, this could pose as an obstacle for your registration and also for your plans for your franchise. So if, for example, if in this situation or scenario that there is an earlier trademark already registered, then you may have to consider rebranding and by conducting your clearance search early ensures that you have ample time to consider your rebranding efforts to see how you can best enter the territory while preserving the value of your brand and your franchise system. Another important aspect of trademark registration is that in certain countries, for example in China and Indonesia, you will require a trademark registration before you can grant your franchise. So without a trademark registration, you might not be able to grant the franchise in those territories. So what are the takeaways for us? The takeaway here for a franchisor is that you should always plan ahead to ensure that your trademark portfolio is aligned with your franchise strategy. And how about for franchisees? For franchisees, I think it's important and paramount that you should be checking on what trademark registrations that your franchisor has in your country. What is the status of these trademarks? Have they been filed? If they have been filed, have they been registered? Because if the trademark has not been registered, then there's a risk that the trademark registration may not go through. Someone may oppose to that trademark, for example. And this may require rebranding of the business. So if you're sinking in costs already and starting with branding efforts, but midway through you realize that, okay, I now have to rebrand the business, there's going to be costs incurred. How is this going to be dealt with? Have you actually budgeted for such contingencies? Okay, the other IP that I would like to just touch on is copyright, because in every franchise, a key component of the IP that's being disclosed and licensed to the franchisee would be the operation manuals, the training manuals, your marketing and packaging materials, even software that may be used in the franchise system. Okay, so for a franchisor, you are granting rights in respect of the use of these materials. You need to ensure that you have the rights to license these materials. And some key considerations that you might want to take into account are, firstly, are these materials developed in-house by your own employees, or have you engaged a third party to develop these materials? If these materials are developed by third parties, then what does the contract say? Does the contract say that you own all such rights? Has the developer assign these rights to you? If not, the default position in many countries could be that the copyright still resides with the third-party service provider. So we need to be very clear to make sure that you hold all the ownership of all these rights. Otherwise, you may end up in this situation where you have paid a service fee for the development of these materials to a third party, and you might find yourself having to pay a second set of fees later on for the assignment of these materials, and that is not ideal. So the takeaway for all franchisors in this regard is, number one, review your employment agreements with your employees and your service agreements with third parties to ensure that the IP, intellectual property in all these materials are developed, belong to and vest in you. Once you are sure about this, you've got your house in order, you you can be confident in licensing this to your franchisees. So earlier we spoke about the importance of securing your IP rights early. And I wanted to highlight the case of Hungry Jack's and Burger King for your consideration here. I first encountered the Hungry Jack's sign when I was about 10 years old. I was then on a family trip in Australia, and we had passed by many Hungry Jack's stores during our trip. So at that point of time, clearly I had no knowledge of intellectual property. But what I knew, however, as a consumer, was that the logo and get-up of Hungry Jack's reminded me of another familiar fast food restaurant, Burger King. And even at that young age, I wondered then if Hungry Jack's was associated with Burger King, or was Hungry Jack's merely imitating Burger King? I was quite confused, really. But what I later found out when I was older was that Hungry Jack's was in fact a franchisee of Burger King. And in fact, it is one of the most successful franchisees of Burger King. But at the point that the franchise was being granted, the mark Burger King had already been registered by a third party. So parties had no choice but to rebrand. And through discussions, it was agreed that the franchisee would enter the Australian market under the name of Hungry Jack's, Jack being the name of the franchisee. So what I took away from this experience was the power of consistent branding and the importance of securing one's trademark rights early. Okay, if Burger King had been able to secure its trademarks early in Australia and license its franchisee the use of the name Burger King, I think this would have certainly avoided any or minimized any confusion in the minds of consumers, especially those who are familiar with the brand name of Burger King and are going to Australia. They would know that this is one and the same. Burger King itself would also have been able to build on the value of the Burger King trademark, and this would have, especially given the success of the Australian franchisee in growing the franchise business in Australia, this would have certainly enhanced the value of the Burger King trademark. So for all franchisors, I think what I'm trying to impress is the importance of thinking about your trademark rights early. The moment you have identified key markets which you wish to expand into, I think it's important to think about securing your IP rights as early as possible, because trademark rights are registered on a first to file basis. So the first in time will have priority in those marks. Now, moving on to pitfall 2. Okay, pitfall 2, I think it's quite common among franchisees and franchisors alike. I will elaborate a little bit more on this later, is signing the franchise agreement blindly. Okay, in the process of signing the franchise agreement blindly, what I actually hope to highlight to all of you is that when someone signs a franchise agreement blindly, it is usually because they have made certain assumptions. So perhaps, whether you're a franchisee or franchisor, we should check our assumptions first before we enter into the franchise agreement. From the franchisee's perspective, okay, the assumption that is commonly made is that the franchise agreement is a standard non-negotiable form, right? Usually after a process of discussions, of checking out each other's operations, of understanding what the franchise entails, the financials involved, the franchise agreement will then be introduced to the franchisee, who would typically see a set of detailed terms and conditions regulating the operation of the franchise, right? A lot of franchisees at that point of time, they may think that, okay, these are standard, they can't be negotiated, or they might be at the point of time so eager and enthusiastic about jumping straight into the franchise that they fear that starting any sort of legal negotiations may get them on the wrong foot with the franchisor. So they think it's okay to just bypass that process and hope that everything goes well. Okay, another third aspect or consideration of franchisees as to why they may actually sign this franchise contract blindly is that they want to save costs. They don't want to engage a lawyer because they rather channel the funds into the setup of the franchise, and you think it's unnecessary cost being expended. Well, I think that assumption needs to be checked because anyone who has ever seen a franchise agreement will know that it's typically a very long, detailed agreement. And because this franchise agreement is drafted by the franchisor and its lawyers, it typically contains many terms that are favorable to the franchisor, and the interests of the franchisee may not be as well covered or addressed in the document. So the risk, of course, is that if you sign off this agreement blindly, are your rights and interests being protected, right? And I know it's not uncommon for franchisees to go in and they look at this set of terms and conditions and they think to themselves, wow, these terms and conditions are one-sided, but then they think, I have no choice, if I don't sign it, then maybe I can't get the franchise. This is like a take it or leave it basis. And the problem with that sort of thinking is that you kind of start the franchise relationship on the wrong note already, because there's this perception of unfairness, uh, of and maybe some sort of discontent, right? That you can't do anything about it. And this may influence or shape your perception of the whole arrangement and even of your franchisor. And this is not the best way to start off any sort of relationship, as you probably already know. So the benefits of negotiations is that it allows parties to actually bring up their concerns, have a discussion about areas of concern. It helps both parties understand clearly the roles and responsibilities and the expectations that each party has of the other. And I think this process of negotiation um, and not only does it clarify and facilitate understanding, um, it also helps to build trust and understanding between parties in the franchise in the long term, which is an important ingredient in any long-term relationship or partnership. Okay, my other observation, is also that for those franchisees who are reluctant to negotiate, I think there's no better time now than to negotiate on your franchise terms and conditions in this time of pandemic. What I've noticed and observed is that franchisees now have a lot more muscle in terms of negotiating terms and negotiating for more expensive scope of terms as well, which franchisors traditionally may have been a little bit more resistant in granting. So certainly there's no better time to start examining the terms and conditions and start negotiating on them so that parties can reach an agreed set of terms that both are happy with before they start off their relationship. Now, from the franchisor's perspective, you may be wondering, why is this a concern that the franchisor might be signing the franchise agreement blindly? Because after all, isn't a franchise agreement prepared by the franchisor? Doesn't it already protect interests of the franchisor? Well, that might all be right, but the franchise agreement may not be the only thing that actually governs the franchise relationship between the franchisor and the franchisee, right? In certain countries, and actually in all countries, you should always review your franchise agreement to make sure it's compliant with the local laws and regulations there. And in certain countries, there may actually be franchise-specific laws and regulations which are meant to protect domestic franchisees. And so because of the protectionist nature of these franchise-specific laws and regulations, you may find that a lot of your contractual terms, your standard contractual terms in your franchise agreement may not be compliant with the laws and regulations in those countries. So it's always a good idea to seek local counsel's advice to find out what sort of laws and regulations are in place that may impact the grant of your franchise, right? Also to get your standard set of terms and conditions reviewed by local lawyers for compliance with local laws in that country. So for those in Singapore and have only been focusing on the domestic market, you will know that in Singapore, we don't really have any franchise-specific laws and regulations. It's pretty laissez-faire, and we just have general general laws that may apply to aspects of the franchise. But in other countries, there may be franchise-specific laws that may also impose disclosure requirements or even franchise registration requirements. So what does this mean? For example, in Indonesia, right, you may be required to file a disclosure document and also a prospectus. You may have to give this document to your franchisee maybe 14, 15 days before the signing of the franchise agreement. You may also have to register this disclosure requirement with the local authorities over there. And this disclosure requirements there'll be a list of mandated information that you must disclose. Sometimes they might require financial information. Okay, they might need a copy of your audited financial statements in the past 3 or 5 years, depending on which country you're entering into. So these are what I'll say additional requirements that a local franchisor may not have encountered before. And it will be important for you to get advice in this aspect so that you are ready when you are ready to grant your franchise. You know that your franchise is being granted in compliance with the local laws. It will be valid and enforceable, and there will be no hiccups along the way where you might be challenged for unenforceable terms in your contract, or worse still, you might have unwittingly committed an offense in the process of granting your franchise. Okay, apart from franchise-specific laws and regulations, which I've been focusing on quite a bit, there also may be other laws, for example, competition laws, data protection laws, employment laws, and even tax laws that apply to your franchise. So again, the important thing to take note of is please check with local counsel first on any additional requirements that may apply to the grant of your franchise. Okay, now moving on quickly to pitfall number 3. Okay, pitfall number 3 is failing to provide adequate protection of your investment. This pitfall, positive way of looking at it, I suppose, is that for a franchisee, when you go into a franchise, there are high setup costs involved. You are putting in significant investment, and you want to make sure that your investment is protected, right? And the question is, have you actually considered in the different ways in which you can protect your investment, right? Even if you are buying a tried and tested business, it still takes time to reap the returns of your investment. And when it's the first time that a franchise is entering a new territory, there may be different factors at work as well that will impact how quickly you can recover your investment, right? So for a franchisee, how can you protect your investment, right? You want to think about, for example, maybe obtaining exclusivity in the franchise. For those with bigger budgets, this may mean negotiating for area franchise rights or master franchise rights so that you can limit market saturation within the area. You can protect your own business against competition from other franchisees, right? For those who are purchasing an outlet franchise, maybe because of budget constraints or you're not so sure and want to test the market, very often for outlet franchises or unit franchises, these are granted on a non-exclusive basis. But I do want franchisees to think about this question. What if another outlet, another franchise outlet opens close by? Is this something that's going to be of concern to you? And if so, then is there anything that you can insert in your agreement to protect you in this respect? Do you need a protected radius around your outlet where you can be guaranteed that there will be no other competing franchisee or even a franchisor himself setting up an outlet near you? So this is something you might want to think about. The other aspect as well is in terms of protecting your investment is to think about the term, the duration of the franchise, right? Is it sufficiently long to allow you to stay on course in the business and to recover your capital and make profit? Do you have a right or option to renew in the franchise agreement? And if so, have you scrutinized the terms of renewal carefully? Are you able to renew at your option, or is it subject to multiple terms and conditions? And are these terms and conditions something that you can reasonably satisfy at the point of renewal? I think this is something that you will need as a franchisee to consider very carefully, because this will have an impact on your ability to recover your investment and to continue to benefit from the investment that you put in and the effort you put in building up the franchise. Another aspect, of course, for franchisees going in to franchise for the first time is that they would need to be guaranteed some adequate support and assistance from the franchisor. So look through the terms of the franchise agreement and see whether you are getting the appropriate amount of support and assistance that you need. So an experienced franchisee versus a first-time franchisee may need very different things. And more experienced franchisee might actually want a little bit more flexibility. So it's important to make sure that the terms contained in the franchise agreement aligns with your needs and requirements. So I've listed some of the areas in which a franchisee may need support and assistance from the franchisor, perhaps in location selection, design and fitting out of premises. Other aspects may be in setting up the franchise, especially with the first outlet. Usually there needs to be a lot more hand-holding and assistance from the franchisor in the first outlet. How about advertising and marketing? What sort of assistance is your franchisor providing to you? One of the benefits of a franchise system typically is that you can ride on the advertising efforts that the franchisor rolls out on a group-wide basis. And this is very helpful so that you don't have to rely on your own efforts to market your outlet, but you can ride on the franchisor's marketing sort of system and engine. Okay. The other aspect as well, of course, is about training. What sort of training are you required to undergo? What sort of training will you be able to receive so that you can run your franchise outlet? Okay, other aspects are supply of equipment, stock, fixtures and fittings, and just general support and guidance. Are you able to tap on them anytime? What sort of commitments are they making to you to help you in the support of your business? One aspect that you might also want to consider is there any scope for localization? What I mean by this, a successful business in one country may not translate to the same sort of success in another country, because there may be local preferences. In the F&B sector, for example, there may be local taste buds may prefer certain flavors, certain tastes. So franchisees may have ideas about increasing and improving their business through some localized products. So it will be important to see if the agreement actually provides for any leeway for localization. And if there are, I think it will be very good for the franchisee to find out what is the process for getting any products or service, or for introducing any sort of localized products and services. So when the time comes and you need it, you know what you have to do. Okay. The other thing as well, I think it's very current, is the COVID-19 considerations. With the pandemic, we have seen how this has really impacted businesses, especially those on a retail front, those in the F&B sector as well. We know that during our experience during the lockdown has shown that sometimes we need more than physical outlets to provide our goods and services. The problem is that in a lot of franchise agreements traditionally, the rights that you are being typically granted are only limited to the premise, right? And if you require any sort of additional channel of distribution or any other channel, such as e-commerce channel, this typically will require the approval of the franchisor. And I think with this COVID-19, with the COVID-19 pandemic, something that franchisees may want to think about now is whether they need to negotiate for more expanded rights beyond their outlets. For example, in the F&B sector, one of the trends is setting up cloud kitchens, right? And a cloud kitchen means that you don't have it's not your typical dine-in outlet where customers come in and they dine in. Cloud kitchens are set up specifically for the business of delivering for delivery services, right? Is that something that you may require as a franchisee, especially if you're area or master franchisee? If so, then this is something that you need to reflect in your terms and conditions. For retail outlets, you might want to think about what sort of e-commerce, social media, marketing rights do you have under your franchise agreement? Think about what you need from the franchisor and start that discussion with your franchisor to make sure that this is properly catered for. Okay, from the franchisor's perspective, when we think about whether your investment is adequately protected, we are thinking about the investment that you have put in to build up your brand and your goodwill and your reputation over the years. So the question is that well protected enough even if you franchise your business to third parties? And one way to ensure that you are getting adequate protection in that aspect is to ensure that you have oversight and control over the franchisee's operations. Okay, so this may take the form of provisions that require branding compliance in terms of look and feel of the business, operations, products and services, ensuring that any changes require your approval. It may also take the form of requiring all marketing activities to be approved beforehand by you before they are rolled out, since this could potentially have an impact on your brand and how your brand may be perceived by consumers. Okay. The other aspect, of course, very important, is operational compliance. How do you ensure operational compliance beyond requiring your franchisee to comply with your manuals and your systems and your procedures, right? Well, one way of ensuring control is to ensure you have sufficient audit and inspection rights so that you can inspect the premises at any time and audit the operations and of the franchisee. Another aspect you might want to consider is whether you need real-time access to the franchisee's POS system, point of sale system, or accounting and CCTV systems. Okay. Another thing to consider about is in the area of exclusivity, as I said earlier, it's not uncommon for franchisees to require an area master franchise or area master franchise rights. So instead of giving an outright grant of a whole area like a big country like China, perhaps you may want to start off granting the franchise over a limited area first, see how that pans out, and if the franchisee is hitting all the criteria, meeting all your requirements, then extending them an option to extend that franchise area to a bigger territory. Okay, the other thing as well that you can make sure to sort of like supervise and give oversight of to ensure that your franchisee is performing in accordance with your requirements is through the imposition of performance targets. Okay, now moving on to the final pitfall that I'll be covering for this webinar, right, is the failure to consider your exit strategy. So at the start of the franchise agreement arrangement, everyone is positive, enthusiastic, and they are just thinking about what a great success this is going to be. And that's all great, right? But what's also important is that we have to be realistic. We have to consider what if things don't work out the way that you've intended. We have to consider what your exit strategy will be. Okay, so for franchisees, right, sometimes for personal or for business reasons, you may think about selling your business, right? But then franchisees should take note that quite typically franchise contracts will have restrictions on sale of business by the franchisee. For example, there may be time limitation imposed as to when the franchisee can sell the business, maybe 3 to 5 years. Maybe the franchisee might be required to hold the business for 3 to 5 years before they can actually sell the business. And if they do sell the business after this time frame, franchisor may require a right of first refusal. This means that the franchisee is obliged to offer the business to the franchisor first on the same terms that it will offer to any other third party, right? Assuming the franchisor does not take up this right of first refusal and franchisees are allowed to offer the business to other third parties, then franchisor very often will hold the right to approve the buyers as well. Okay? This is quite understandable from the perspective of the franchisor because they had chosen you, they'd gone through a whole process of selecting you as your franchisee, and they had entered this franchise for the long haul, right? And so the partner that's going to take over you will be very important to them. They need to be assured that this is the right partner for the franchise, that they are comfortable working with this buyer. Okay? But for the franchisee, this is something that will really impact your ability to transfer and sell your business. So this is something that you want to pay a little bit of attention to before you enter into the franchise. Okay, another thing to consider is when the franchise ends, what's going to happen to IP assets of the franchisor? Okay, what's going to happen to leftover stock, equipment, assets? Is there a process for dealing with such leftover stock, equipment, assets? Does franchisor have the right to buy over such assets, or can franchisees just sell this on the general market? These should all be clearly set out in the franchise agreement. Okay, another consideration, of course, is are there any restrictions on post-franchise activities? Can a franchisee set up a similar business after the termination of the agreement, right? And typically, there are non-compete clauses that would be contained in the franchise agreement, preventing a franchisee from setting up an identical or similar business in the territory, and usually for about 2 years or so, okay, before the franchisee can actually go on. Now, the duration of this restraint can be negotiated upon between parties. And another consideration that franchisees may also have is, can they continue to operate at the existing premises? Some of these premises are premises that are owned by a franchisee, or they may be leased for a term that goes beyond the franchise agreement. So franchisee may be bound by this lease agreement, but the franchise term has ended. Can they continue to operate at that premise? And if so, what can they do at that premise? Because I think many of you may be familiar with the cases of Gong Cha and Liho. As you know, the Liho owners were actually previously franchisees of Gong Cha in Singapore. And when the franchise ended, almost overnight, all the Gong Cha outlets were rebranded in Liho as Liho outlets. I mean, kudos to Liho for such a synchronized strategy in changing all the outlets, because then they were able to sort of maintain that customer base that they have had in those places. But for franchisors, you will have to consider, is this an outcome that is satisfactory to you? And similarly, not just in the bubble tea market, we have it also in the frozen yogurt market. You remembered that the Spanish yogurt brand Yao Yao, which was very popular in Singapore as well, that was operated by a franchise, and overnight again, that franchise terminated and the franchisee set up Yole, a similar frozen yogurt business at the same outlet. So think about it, franchisors and franchisees, as to what's going to happen when the franchise, if and when the franchise arrangement should end. What is your exit strategy, and whether your franchise agreement adequately reflects your strategy that you have chosen. Okay, and that brings me to the end of the webinar. Thank you very much. If you have any questions, I believe there is actually some time for questions.
Yes.
Over to you, Daisy.
Thank you, Geraldine. Thank you so much. We have 3 minutes for Q&A. This is your only chance to ask Geraldine any questions you have on all the 4 pitfalls that she shared. She won't be joining us for the next 2 days. So if you want to ask her any question, this is the best time. But otherwise, right, I think just to quickly summarize, for me, the best takeaway from your session today was not to make assumptions, not to assume that the franchisees do not have rights to negotiate in that whole agreement between the franchisee and franchisor. I thought that was a really good takeaway, because previously when I was working for another brand that is also a franchise brand, the franchisees always take on whatever agreement we took on. They didn't negotiate because they didn't know what it was their rights to negotiate actually. So then, yeah, when it came to COVID-19 period, it became a little bit difficult because they wanted to exit, but then there were no exit clause that protected them. So they had to pay and all. So yeah, exit strategy, your last point was also a good point to remember for all the potential franchisees out there. So if you're a business owner or you are a aspiring business owner looking to take on any franchise brands through this show, remember these 4 pitfalls. Geraldine, could you go through the 4 pitfalls with us again?
Okay, sure, essentially. The first pitfall is failing to secure your IP rights and protection. Okay. The second pitfall will be signing the franchise agreement blindly. For the franchisees, is making the assumption that the terms cannot be negotiated. For the franchisors, the assumption that is usually wrongly made is that the franchise contract is ready to be signed and they have no need to check local laws and regulations. The third pitfall will be failing to provide adequate protection of your investment. So this actually goes into the meat of the terms and conditions of the franchise agreement. You have to look through it to make sure that your investment as a franchisee or a franchisor is adequately protected in the different provisions in the agreement. And finally, the last pitfall will be failing to consider your exit strategy. Okay, so that brings me to the end of the 4 pitfalls.
Okay, thank you very much for the summary. Actually, we have one question that come in here, but we only have 30 seconds for this. I quickly read it out. If the
Okay.
if the franchisor refuses to negotiate the agreement because the franchisor wants all franchisees to sign the same agreement, what are your views on this?
Okay, so I think from a franchisor's perspective, their standardization is important, and I think honestly, a lot of aspects may be standard, right? They have to be there, but there's certainly a lot of aspects that can also be tweaked, and these, I think as long as you can show why it's a real concern to you, your franchisor should be reasonable enough to be open to discussions on this. And I think this is also reflective of the attitudes of the franchisor. Someone who is on adopting a take it or leave it sort of attitude, that kind of also bodes, that's a little bit worrying, I think, for the franchisee in terms of how this franchise relationship is going to be. Because I think it's important for both franchisor and franchisee to work together to agree on a realistic set of terms and conditions, because that's the only way to sort of assure and attain success for the franchise arrangement and relationship.
Thank you so much, Geraldine. Okay, for everybody else, Geraldine's presentation slides will be put up on our post-event site. And at the same time, if you want to watch this video again, you can always watch it after 20th of November when the video is put up on demand. So thank you so much, Geraldine, for taking time off to join us today, for answering the questions. We are very grateful to have you, and there's a lot of takeaways for me, even as a listener over here. So I wish you a very pleasant week ahead, and I hope everyone has a fruitful event up ahead. Thank you very much. I'll end the session here.
You're welcome. Thank you.
Bye
Bye.
bye.